no, but it does require some explanation. First, a business cannot get a discharge under Chapter 7. Only individuals and legally married couples are eligible for discharges in Chapter 7 cases, and this is explicitly stated in the Bankruptcy Code. In fact, discharges under Chapter 7 are granted under Section 727 of the Bankruptcy Code. And the very first portion, Section 727A1, it says, the court shall grant the debtor a discharge unless the debtor is not an individual. So explicitly, the Bankruptcy Code says you can't get a discharge if you're a business. The second reason is when a business goes into Chapter 7, the court will appoint a Chapter 7 trustee to the case. The Chapter 7 trustee then takes all the assets of the business and liquidates them and has a pot of money. Then the business's creditors are invited to file what are called proofs of claim in the case. A proof of claim is a standard document. In fact, here in the Central District, we've got a form for it, in which the creditor says, this is what I'm owed, this is the basis for the debt, and typically the creditor will attach to it some sort of supporting documentation. That then is how the creditor gets to participate in the payout of the business's liquidated assets. In fact, Chapter 7's title is liquidation. Now, at the conclusion of that process, the business ceases to exist because in the liquidation, the business is no longer. So that's the second reason why a business can't get a Chapter 7 discharge. So what's the point of this Chapter 7 filing then if there is no discharge? If the business has a lot of assets and a lot of debts, and the owners can see, this one's just not going to pan out. They can see the handwriting on the wall. It's time just to cash it in. But they don't want to do the legwork of selling all the assets, getting a pot of money, contacting the creditors and distributing the money out of that pot with no creditor really being happy unless it gets paid in full. The simple answer then is do a Chapter 7. You file the Chapter 7. The Chapter 7 trustee then takes over, takes the business, liquidates it, and then has money to distribute to the creditors, files any final tax returns, and the owners no longer have that headache. But if the business has no assets, what then does the Chapter 7 trustee have to do? There's nothing to do. And so it's a complete waste of time. It's also a complete waste of court resources if a business files a Chapter 7 and it has no assets, because then all you've done is filed some documents, wasted the time of the Chapter 7 trustee appointed to the case, and you've accomplished precisely nothing. As a result, judges take a dim view of a business filing a Chapter 7 if it has no assets. And in fact, here in the Central District of California some years ago, one of our judges, who, a little fact for you, is the longest serving bankruptcy judge in the history of the nation, fined or sanctioned the attorney who filed the Chapter 7 $30,000 because the attorney had filed a Chapter 7 case when there were no assets for the Chapter 7 trustee to liquidate. I'm pleased to report I was not that attorney. And so really, there is no point in doing a Chapter 7 for a business if the business has no assets. Now, that also spills over into any personal liability that the owners have. Because when I get people calling saying, I've got a business, I'd like to shut it down, put it into a Chapter 7, and I talk to them a little bit, they are under the mistaken notion that if the business goes through a Chapter 7, it will absolve them of any personal liabilities they have. Well, first, since the business can't get a discharge, there's no business in the case, or there's no discharge in the case. So as a result, nobody gets absolved from liability, including the owners. Secondly, the business typically is a corporation. When someone creates a corporation, they create a new person. Now, I freely admit it's not a biological person, but it's a legal person nonetheless. And it has its own assets and its own liabilities, its own income, its own expenses, its own financial life. And that's very, very important for the owners because the point of incorporation is to limit liability. What do I mean by that? Well, a simple example I think will help to illustrate what's going on here. Let's say you've got a delivery business and you send Charlie out Monday morning with 10 pallets of widgets across town. Now, you didn't pay close attention to Charlie's demeanor. It turns out Charlie had a rough weekend and he's not seeing clearly. And he gets behind that wheel, drives down the road, plows into Rachel's car, smashes it up. She's badly injured. She's going to need reconstructive surgery. And this is going to be hundreds of thousands of dollars. Is she going to sue Charlie? Well, she can, but she's probably not going to recover a whole lot out of Charlie. Well, she can sue the business, but the business might not have enough insurance per vehicle to cover all of her expenses, the replacement of her car, her medical care. So what does she want to do? She's got to go after somebody that's got the money. She wants to go after the principal. But the principal says, hey, wait a minute, I didn't smash into her car. Well, in a situation like that, does the principal have liability? The point of the incorporation was to create a shield. We refer to it as a corporate curtain between Rachel and the principals. She can go after the corporation, but she can't go after the principals unless she can pierce the corporate veil. How is that done? Well, remember, this corporation is supposed to be a separate person. And as long as it's a truly separate person, then Rachel can't come after the principals. How can she establish that the corporation is not truly a separate person? She has to establish that the business and the principals are alter egos of each other, that there's nothing really separate about this business. It's really the same entity. Here's some ways that Rachel can try to do that. Number one, Rachel can get a forensic accountant and look at the books of the business to see, was it adequately capitalized at its inception? If it wasn't, then it's really not much more than just a shell. The second thing is, was the corporate life maintained? That separate personhood. And there, Rachel is going to have her forensic accountants look at the books to see, were there regular meetings of the board of directors? At those meetings, did the board of directors take minutes? If that's not present, then it doesn't look like this business really has a separate life apart from the principals. The third way is by showing that there's been a commingling of funds, that the principals treated the business's money as if it was their money, or they treated their money as if it belonged to the business. How does she do that? Well, she's going to get those forensic accountants to look at the bank records. And if they can see, oh, well, the principal, let's take a simple example. It's one owner business. The business was on the skids for a while. The principal took $100,000 out of his savings, dumped it into the corporation, got the thing going. Now it's humming along, took the money back out. Now, if there were no loan documents that indicate an arm's length transaction between the principal and the business, what it looks like is the owner was treating her personal money as if it belonged to the business. Commingling funds. That starts to look like it's not a separate person. Or the other side of the coin. Principal's having a dickens of a time making his mortgage payment. So he dips into the till, grabs some money, makes his mortgage payment. A couple of months later, he pays it back. No harm, no foul, right? Oh, wait a minute now. Principal treated the business's money as if it was his money. Another commingling of funds, eroding the separate personhood. So when I have somebody call saying I want to do a Chapter 7 for my business, one of the first things I need to do is disabuse that person of the mistaken belief that putting that business into a Chapter 7 is somehow going to get rid of the personal liability that owner has to any creditors. And so we talk a little bit about this idea of piercing the corporate veil, that with small businesses regularly have that commingling of funds, and they sort of leave the meeting of the board of directors by the wayside, and maybe they started the business on a shoestring. So that's really going to be a big problem there. On top of that, the owner may have signed personal guarantees on the debt. So not only does the creditor have the ability maybe to pierce the corporate veil, but also to go after the owner as a co-debtor. So for example, let's say the owner went to the bank. ABC Bank said, I'd like to borrow $500,000 for my business to kind of really get it going. Bank looks at the records, and the bank, if I can anthropomorphize the organization, says, all right, we'll lend you the money. Sign here, and the owner signs as president. Oh, we're also going to need you to sign here as human being. What do you mean? I am a human being. I just signed. No, you signed it as the business. Now we want you to sign it as a human being, as an individual. Now you have personal liability. So since the business can't get a discharge, the business isn't going to get a discharge of that debt. But even if it did, if it's a separate person, its discharge would only cover its own liability, not the co-debtor's liability. So a little bit of a long-winded answer, but it's important to understand the moving parts in this. The long and short of it is, number one, the business can't get a discharge, and if it has no debts, there's no point in filing a Chapter 7 bankruptcy case for the business. And number two, even if it did make sense, and even if the business had assets, unless after the liquidation of the assets, the creditors get paid in full, the owner has a potential liability on those debts. As a result, in a situation like that, it's probably a better move for the owner to think in terms of filing a personal bankruptcy to deal with those debts, because if the business has no assets against which creditors can collect, well, the creditors can sue the business, but they aren't going to collect anything at all. Well, they're going to be interested in going after principals anyway. So at that point, the principal really needs to think about a personal bankruptcy of his own or her own.